Good afternoon, Judge Rogers.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well.
Okay, I see you don't want to know how I am. You're not interested.
Then I'd have to ask everyone.
Well, I'll tell you anyway. I'm fine. Thank you very much for making yourself available for consideration for one of the vacant positions in the Constitutional Court. We really appreciate the fact that you made yourself available. I do want to make a disclosure that I encouraged you to make yourself available. I think you were not thinking of making yourself available. I did so because I think it is the responsibility of heads of court to try and encourage more candidates to make themselves available so that this body has a wide pool, a wide choice when they consider the filling of positions. Obviously, being encouraged to make yourself available doesn't carry with it any promise. But it is something that many years ago, Chief Justice Charles Carlson and heads of course took as the right thing to do to try and encourage more candidates to make themselves available. So I thought I must just make that disclosure. You, unlike the other candidates for the positions in the Constitutional Court who have been before this commission a few times already, you are coming before this commission in respect of the Concord for the first time, is that correct?
That's right.
Yes. With regard to the other candidates who have been to this commission in regard to positions in the Constitutional Court, we, or many of us, might not have had much to ask because we have interviewed them before. But with you, it's for the first time. I will ask you certain questions, and after I've finished, it will be an opportunity for the rest of the commissioners to ask you questions. Are you feeling comfortable? Are you comfortable?
Yes, as can be expected in the circumstances.
Okay, all right. I see that in terms of your academic qualifications, you obtained in 1982 a BA degree at the University of Cape Town, and you obtained it cum laude. Is that correct?
That is correct.
And that was 1982. And then you obtained in 1983 your BA honors from the same university. Is that right?
That is correct.
And then in 1985, you obtained your LLB magna cum laude. Is that correct?
That is also correct.
Yes. And you then served articles of clerkship at Sonnenberg, Hoffman, and Galombik from 1986 to 1987. Is that right?
Correct.
Yes. But after your articles, you didn't get admitted as an attorney, or you did get admitted before you went to do pupillage?
I did get admitted
Yes.
to preserve my right to practice as an attorney if I decided I didn't like the bar.
Yes. And then you started at the bar in 1988,
That is correct.
and you practiced as an advocate at the Cape Bar up to from 1988 to 2012. That's about how many years?
I think it was about 25 years.
Yes. But about 10 years into your practice as an advocate, 10 years or so, maybe 11 years, you obtained silk, is that right?
That is true.
Yes. So you obtained silk, I think, in 1999,
Correct.
and you practiced as a silk from 1999 up to 2012. And then you were appointed as a judge in the Cape High Court in 2013?
Correct.
Yes. And you remain a judge of that court to date, is that right?
That is so.
But in the meantime, you have acted in the Supreme Court of Appeal?
Yes, I think for 7 terms over a period of some years.
Yes. And you have also acted in the Constitutional Court?
I acted for the 3rd and 4th terms last year, yes.
Yes. How did you find that experience?
I'll be honest, I think I'm a hard-working person, and I've got a fair experience of High Court work, SCA work, and then I had 2 terms in the Constitutional Court. I found the work very interesting, but the pace of work was quite unrelenting. It's a grueling workload in comparison with the other courts. That was my experience, but at the same time, one is working with colleagues who were very collegial. I never felt when it came to legal issues that an acting justice's voice was less important than anyone else's. Debates were always courteous and friendly. And of course, the court is generally involved in constitutional or other legal issues of considerable importance. And that is intellectually satisfying in addition to being important for the administration of justice in the country.
Well, I'm going to say this, that when I approached you to invite you to come and act in the Constitutional Court, you seemed surprised. Is that correct?
I was surprised.
And your first response was you thought you didn't know constitutional law enough.
I'm not sure I would have put it quite as bluntly as that, but that I had conceived
You were very humble about, about your knowledge of constitutional law.
I did think that my experience was more generalist, plus I had some specialized knowledge in fields which weren't overtly constitutional, like tax and pension fund law and company law.
Yes. Well, speaking for myself, I think that during the time that you have acted in the Constitutional Court, I have seen you making very important contributions. Whatever thought you may have had that maybe you were not so experienced in constitutional law, I can say I didn't see that.
Thank you.
Yes. How many judgments have you been able to write while you were at the Constitutional Court?
I have written 2 judgments where I was the nominated scribe. The one was mentioned in my questionnaire, the Shiva uranium case, which was a company law case in the field of business rescue. The other judgment, which was reserved at the time of my questionnaire, was a pension fund case. I think that's item item 16.5 of the questionnaire that was reserved on 30 November last year, and that was delivered on 14 March of this year. Both of those judgments were unanimous judgments. I wrote the majority judgment in the first of the Electoral Commission cases which we heard in September. That was at the invitation of one of the senior members of the court who formed part of that point of view at the time.
Yes.
And then I've recently written a majority judgment in a case where judgment was delivered a week or two ago, MVM versus Tembisa Hospital, on a jurisdictional issue. And then I also wrote a unanimous judgment in a case where there was not a hearing concerning the rescission of judgments taken through the registrar by the South African Revenue Service. That's Barnard Labuschagne versus SARS. Those are all now on the SAFLI website under the Constitutional Court database.
You referred to yourself earlier on as a generalist. You said you thought you were a generalist. I take it that that doesn't necessarily mean that there are no specialist branches of law in which you got involved even while you were in private practice, because I know you did some labor law work, so you would have got involved in some specialist branches of law as well.
Yes, in my early days at the bar, I did quite a bit of labor work, and you will see from my questionnaire that I did act for a month in the labor court quite early on.
Yes.
I specialized when competition law assumed importance in South Africa in the early 2000s. I became involved in that sphere, and I am a judge of appeal of the Competition Appeal Court. Income tax, or tax generally, was a significant part of my practice. And then pension fund law, I not only did pension fund cases, but sat as the chairperson of tribunals dealing with the apportionment of pension fund surplus, and then also company law more generally. And it so happens that the two judgments which I was asked to write in the second, third and fourth terms respectively happened to involve company law on the one hand and pension fund law on the other.
Yes. Now, in terms of your practice before you went onto the bench, would you describe your practice as also having been of a generalist nature? Or
yes,
not really?
It was weighted towards those fields that I have now mentioned, but I did a certain amount of administrative law and other public law work. I did some delictual and insurance work. I didn't do criminal work, although as a judge I have done quite a lot of criminal work.
Yes. And then as a judge, in all the courts in which you have been, the High Court as a permanent judge, and also acting in the Supreme Court of Appeal, your judgments have covered, what kind of branches of law have your judgments covered, generally speaking?
I think it is a very wide field. I have given judgments on constitutional and administrative law matters, a fair number of review judgments, but I have given reported judgments in the criminal sphere, in company law, contract law, delict. I think it covers a very broad sphere.
Yes. And we have got here, you gave us in your questionnaire a list of reported cases in which you appeared as a counsel while you were in private practice. Is that correct?
I'm not sure I did give you that, no.
Oh, I thought I saw it. You didn't give us that. But I take it there would be quite a long list.
Yes, as counsel in the law reports,
as counsel, yes.
I would have given that information, I think, when I was applying for position in the Western Cape High Court.
Yes, okay. But also you have given us in the questionnaire quite a long list of reported judgments that you have written in the different courts. Is that correct?
Yes, that's Annexure A to my questionnaire.
Yes, yes. And you said in the SA you acted quite a few times, is that right?
I think seven terms in all.
Oh, is that so? So,
They weren't sequential. I think I acted for 3 terms and then for 2 and for 2.
yes. Well, 7 terms would be like, if you put them together, would it be like 2 years, 1 term?
That's correct.
Yeah, yeah. Or maybe just under two years.
Yes, sorry, just under 4
Yeah.
terms would be a year.
Yeah. Okay. Of your judgments that you have written in any of the courts, which one do you say, would you say, has made the most important contribution to our jurisprudence, if you are able to say?
I would probably say the third of the cases I mentioned in 16 of the questionnaire, the Nkata case, Nkata versus First Rand. I say so not necessarily because it was the most complex or difficult of the legal issues, but it highlighted an aspect of considerable practical importance in all matters arising under the National Credit Act about the circumstances in which credit agreements which have been terminated because of default can be reinstated. And I was reversed by the SCA, but then reinstated by the majority in the Constitutional Court. And I know from experience in the High Court that it is a decision which has had a lot of practical effect on the way judges grant orders. I know in my own court I had a special form of order in bond default cases which built on this and accommodated a sufficient time period to enable debtors to potentially reinstate their agreements and so not lose their property. So I would mention that case.
Your judgment in the Constitutional Court in the Tembisa Hospital matter, how would you say it contributes to resolving the issue of jurisdiction in the Constitutional Court?
Yes. For the information of the commissioners, the question there was whether the Constitutional Court had jurisdiction in respect of a case concerning causation in hospital negligence where a baby had tragically suffered from lifelong cerebral palsy as a result of negligence. And it was a difficult question as to whether the causation issue in some way implicated the Constitution or a legal question sufficiently closely to engage the court's jurisdiction. What I did, I'm not saying it hasn't been done before, but I went back to the language of Section 167 and sought to base the jurisdictional outcome on giving a certain interpretation to the words, what is a constitutional matter, because that's the phrase used in Section 167, a constitutional matter, and the other jurisdiction is, does the case raise a arguable point of law of general public importance? And I sought to give an interpretation to what is a constitutional matter and when can a case be said to raise an important question of law. And I certainly utilized and saw myself as giving effect to judgments which the Constitutional Court itself had given. And in that, I don't think it was necessarily groundbreaking, but I think it gave a particular interpretational coherence to a number of disparate judgments which the Constitutional Court had given on that subject.
Yes.
And I may say that I think it is, when I first came to the Constitutional Court, I was a little bit frustrated at not being able to grapple with the facts of cases. Having come from the High Court and with my SCA experience, when one felt that a court lower in the hierarchy had gone wrong on the facts, there's a natural tendency to want to intervene and do something about it. But I had to learn that an apex court sitting with 10 or 11 justices can't be involved in a second or third reappraisal of facts. And sometimes potentially bad factual decision-making just has to be left alone. No system of justice can always ensure that every decision will be factually right. I don't wish to suggest anything about the Tembisa case itself as to what the facts would have, what a factual analysis would have led to if we had had jurisdiction. But I'm just saying that I think it is important that what the apex court deals with should be subject to limits. And if the framers of the Constitution expressly imposed limits on the Constitutional Court's jurisdiction, one should not necessarily seek to circumvent that in difficult cases by dressing up as a constitutional issue something which is just a factual reappraisal.
Yes, while you were at the acting in the Constitutional Court, did you get an opportunity of writing a judgment which declared some legislation unconstitutional?
No, I don't think I've done that.
But you sat in matters where another colleague wrote a judgment declaring some legislation as unconstitutional?
I actually don't think such a case served before the court in the third or fourth terms last year. I might be wrong, but I don't think that is so.
Yes. While in the High Court, had you had a chance of dealing with such a matter?
Yes. One of the cases, I think I might have mentioned it in my questionnaire, not necessarily in the list of 10 significant cases, but in tracing the fate of some of my judgments on further appeal. One was concerned with the search provisions in the Customs and Excise Act. Gertner that would be in paragraph 16.4, the third bullet, Gertner versus Minister of Finance. In that case, I declared certain provisions of the Customs and Excise Act unconstitutional. The Constitutional Court upheld the declaration of invalidity, but whereas I'd given a more extensive reading in as to what would be an interim position while Parliament looked at the matter, the Constitutional Court gave a much slimmer or shortened version of the reading in.
Are you familiar with the doctrine of subsidiarity?
Yes.
Yes. Do you want to say a few words about it?
The doctrine of subsidiarity entails that where the Constitution envisages that certain fundamental rights will be the subject of national legislation, and the national legislation comes into existence, then if one wishes to launch an attack, if one wishes, for example, to say that one has been the victim of unfair administrative action, or that your labor practices, you have been subjected to an unfair labor practice, you should not ordinarily go back directly to the Constitution and base it on Section 23, for example, but to base it on the legislation which is intended to regulate those constitutional rights. And if if the litigant considers that the national legislation doesn't do so satisfactorily, or does so in a way which is inconsistent with the Constitution, the proper course is to attack the constitutional validity of the subsidiary legislation.
When you dealt with the matter in the High Court in which you declared legislation constitutionally invalid, I guess that you would have dealt with a Section 36 analysis as well?
The proportionality?
Yes.
Yes.
Yes. Okay, all right. I'm going to now allow commissioners to put questions to you, and largely when they put questions to you, they will be seeking to satisfy themselves whether the information you will give them enables them to see how your appointment would meet the selection criteria that this commission has previously adopted and uses. I won't read all the criteria, but they include the question whether or not a candidate has integrity. They include the question whether or not you have the necessary energy and motivation, and whether you are a competent person, and that is technically competent, and whether you have capacity to give expression to the values of the Constitution. It will also, the criteria also include asking the question what message your appointment would give to the community at large. I will now allow commissioners who wish to put questions to you to do so. I'm looking around. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon. How are you?
Very well. I reckon that you have presided over high-profile public cases which attract very, very much interest to the population of South Africa, like the elections, like football and all of that. How do you describe your judicial temperament?
I'm the sort of judge who engages with counsel in argument. I don't sit silently and then come up with a decision at the end. I think I'm generally regarded as courteous and polite, but I can be quite vigorous in engaging counsel, and precisely how one undertakes that exercise will depend on the experience of the counsel, because one doesn't want to browbeat a junior practitioner, but if you have a senior experienced practitioner, they enjoy a debate, and I knew from my own time as an advocate, if I went to the appellate division or the SCA and spoke for 15 minutes and didn't hear anything, I was like a lost ship at sea. I'd rather debate issues.
Okay, the second and last question. You declared certain laws, including the correctional service law, unlawful, and that judgment was upheld, for example, by the Concord, where they made a declaration of invalidity in terms of Section 172 of the Constitution. And once that happens, normally they refer the matter back to Parliament for consideration, and that they prescribe that Parliament must take 18 months or 2 years to finalize the legislation. In your view, do you think that is sufficient? I'm speaking as a member of Parliament, and once that happens, we run around, spend sleepless nights, especially when it pertains to Section 74 bills or Section 76 bills which require the concurrence of the provinces. Do you think that 24 months is sufficient in that respect?
I'm not entirely familiar with every process which Parliament has to follow, and that it's not only their processes, but what other calls there are on parliamentary time and what other legislative business has to be dealt with. I suppose at the time that the court is seized of the question whether it should suspend, and if so, for how long, I think it would be for the responsible minister or ministers who are cited for the state when legislation under their aegis is being declared invalid to put up the evidence as to what a likely timeline for dealing with it is. Otherwise, the court may be left in the dark. But I can understand that there might be instances where 24 months might not be enough. In the case of the search and seizure provisions in the Customs and Excise Act, which was the one which I declared invalid and which was upheld by the Constitutional Court, that followed a number of other cases where that was one of those interesting cases where Parliament could look at some of its other legislation where it had got it right and use that perhaps as a model. But they just hadn't caught up in the case of the customs legislation.
In the interest of time, it's okay. Thank you very much, CJ.
Thank you very much. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Rogers.
Good afternoon.
I'm this side, on your right.
Sorry, yes.
Judge Rogers, in your publication, High Fees and Dubious Practices, you seem to acknowledge that high fees are an impediment to access to justice, especially for the poor. Could you just summarize and take us through your thoughts as captured in this publication?
I was particularly concerned with the fees of advocates. That was something of which I had personal knowledge. And I didn't understand how many people could afford the very high fees. Now, just from my personal perspective, I thought however good an advocate is to be, of course I'm a bit out of that game now, but at that time to be paid 20,000 or 24,000 rand a day seemed a great deal of money, however good you were. So I thought the basic level of fees was too high. I also thought that some of the practices which had crept into the way advocates charged tended to exaggerate that, because you've probably heard of this thing called collapse fees. You reserved for say for a week in a month's time, the case is going to run, and then it gets settled. And counsel have negotiated themselves a collapse fee where they get paid for the full week or for 2 or 3 days, even though the case doesn't run. I personally was opposed to that. I can understand that if a person really takes themselves out of circulation for a long time, you might have to have some collapse arrangement. But I never found in my practice that if a case settled, I didn't have something else to do on that day. So I thought collapse fees were a bad thing. And then I also thought the tendency, it wasn't so much in the Cape, but I think it was and might still be followed in Johannesburg, of junior counsel tending to charge 2/3 of the senior advocate's fee tended to drive up fees. So even if the junior's normal rate might have been 5,000 rand a day, if 2/3 came to 9,000, he or she would end up charging that. But to be honest, when it comes to access to justice, I suspect that even if advocates' fees were more moderate, even if you cut them in half, the indigent people can't afford to pay that. And access to justice then depends on legal practitioners firstly being willing to do a reasonable amount of work pro bono, and then it obviously also depends on adequate legal aid, a legal aid system.
Thanks. My last question, Judge Rogers. What is the prestige which comes with having your articles cited as yours seem to be cited many times?
Yes, I'm not sure that I haven't followed it. I'm not sure my articles are cited that often. I know quite a few of my judgments are cited subsequently as precedent. I don't know. I suppose it's human to be pleased that other people have found what you have written persuasive or useful. But I haven't particularly tracked how my legal writing outside of judgments has been received. I do know one or two Labour Court judges, for example, referred to my article about high fees. I think I was criticised rather than praised for what I said about silk. So it hasn't always been on one side.
Has your views changed about silk now?
They haven't, but I've given it up as a lost cause.
Thank you, Judge Rogers. Thank you, CJ.
Thank you very much. Commissioner Muiman.
Thank you, Chief Justice. Good afternoon, Mr. Rogers, Judge Rogers.
Good afternoon, Mr. Moimang.
Just one question from my side. In certain corners of the NGO, there has been a reflection on the critique of our constitutional democracy and a silent yearning for a return to parliamentary democracy, which characterized our system of governance prior to 1994. Do you think that that could be a cause for concern for the return to, if one is to parallel what was said by Malan, D.F. Malan, in 1952? Allow me just to paraphrase what he said. It was in response to a call to set aside the law that the National Party passed to remove a colored from the common voters roll. Malan said as follows: if the court should declare this act of parliament invalid, it stands to reason that it would be a serious matter for parliament and for the country. It would mean the undermining of parliament sovereignty. It would mean that the judicial authorities would assume powers belonging exclusively to a legislature. What is your view with regard to that? Thank you.
I think the Constitution as the ultimate source for the power to declare a law invalid, it mustn't itself be viewed as just any law. It is a very special foundational law sitting above all of us in all three branches of government. And I think that one is not, if courts properly recognize the limits on their powers without intruding into policy-laden choices about legislation or about executive decisions, then the power in those cases where plainly the Constitution has been infringed is essential if we are to have a constitutional democracy. I suppose whether as a matter of personal choice politically one prefers to live in a constitutional democracy or a parliamentary democracy depends on who you ask. It is possible that people who are in the majority will say, I like a parliamentary sovereignty. But I think in a country with a history like ours, where one doesn't have an homogeneous population, where one has enormous tensions which exist because of a long and ghastly history, I think to hand power back supremely to a parliament uncontrolled by a constitution would be dangerous, and we know what was the result of parliamentary sovereignty in an apartheid regime, or in fact until 1994.
Thank you. The last one from my side. One of the cases that you referred to is the Central Energy Fund matter that involved the 10 million oil barrels. What was the rationale behind setting aside the sale? I'm raising it in the within the context of the crisis that is beginning to emerge around oil, given the battle between Ukraine and Russia. Thank you.
I don't want to say too much about it because I know the case was argued in the SCA and judgment is pending, but that was a case where I'm not sure how much you have read about, or if you've read the judgment, but it was a case where there was a significant delay on the part of the Central Energy Fund and the Strategic Fuel Fund in bringing their self-review, which is what they did. They sought to apply to set aside the disposal of the oil barrels, so they had to overcome a significant delay. But on the other hand, there was a principle which the Constitutional Court had formulated to the effect that even in the case of a significant and unexplained delay, if the violation of the law is so clear, one must intervene to set aside. And the big question there was, well, what about the financial consequences? I think it turns out nobody could have guessed back in whenever that was, slightly more than a year ago that I gave that judgment. At that stage, I think it probably turns out better for the CEF that it was set aside, because with oil prices at $115 or $120 a barrel, even if they have to pay a lot of money to the people who had the oil and then had to give it back, I think they're still a lot better off than having to replace all the oil at $120 a barrel.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you. Justice Betze.
Thank you, Chief Justice. Good
afternoon, Judge
Justice
Betze.
Rogers.
Yes.
I will not seek to question your attributes as a good judge, such as experience, scholarship, dignity, forensic skills, and the capacity for articulation, diligence, integrity, objectivity, and energy. But I have two propositions that I want to put to you and then invite you to respond to them. As you would know, the Constitution deals in Chapter 8 with courts and administration of justice. You touched upon that earlier. Section 167, which establishes the Constitutional Court, confers the jurisdiction on the Constitutional Court, and then there's Section 167(4), which confers exclusive jurisdiction on the Constitutional Court. And if you come then to Section 168, establishing the Supreme Court of Appeal, the Supreme Court of Appeal can entertain any and every case which falls outside of the exclusions stipulated in the Constitution, which then means that it has a wide scope of cases that it does. And I was made to understand that this is what was closest to your heart. Hence, you made yourself available for a vacant position in that court. How do you wish to respond to that general proposition?
As the Chief Justice disclosed at the beginning, I was invited to put my name, or asked to think carefully about putting my name forward, and as he says, without any suggestion that it came with any expectation that I would get the nod, as it were. I thought about that, and I also spoke with Justice Meyer before reverting to the Chief Justice, or the ACJ as he was then, about his invitation. And I came to the view that not only was it an honor to be invited, but that I should try it out to see how I experience life at the Concourt, if only for 2 terms. I found there that, firstly, I didn't feel out of my depth in the matters that were truly constitutional or public law. I saw that there were, in fact, important contributions which a generalist lawyer could make, and which I think I have made during my acting stint there. As I said, it's a very hard-working court, but of course everything it does, or just about everything it does, is important. As against that, the SCA certainly has a wider jurisdiction, and, for example, it enables you to grapple with facts, and I've never been a judge who shies away from dealing with the facts of cases and trying to confine it to law. I enjoy mastering the facts of cases, and the SCA allows you to do that. There's less scope for it in the Constitutional Court. But as against that, the SCA is not the final word on the matters of greatest importance to the country. Normally it will then go further. And as you will know, interspersed between the interesting matters which the SCA hears are a number of fairly mundane or humdrum cases. And I think that is largely a consequence at the moment of the fact that whereas the Constitutional Court has almost exclusive control over what cases it hears, and therefore makes sure that it only hears important cases, the SCA, about half of the cases that it hears are cases where leave was granted by the High Court. And often, as you will know from experience, leave is given where perhaps it shouldn't have been given at all, or where it should have been given to a full court. So I can see ups and downs. From a purely personal point of view, I can see aspects of Constitutional Court work which I enjoy, and aspects of SCA work that I should enjoy. And having been encouraged by the CJ, and I should also say several other people urged me to think carefully about it, I take the view that if what I have to offer is thought to be useful and valuable to the Constitutional Court, I should not hold back just because there might be aspects of SCA life that I would prefer. It is not purely a personal matter. All I can say is that I believe I could find work in either of those courts invigorating, but intellectually, the Constitutional Court has the advantage of being decisive in shaping the law in a way which the SCA only does where its judgments are not taken on further appeal.
Thank you. And you did mention earlier on that you acted at the SCA for 7 terms and 2 terms at the Constitutional Court. And I'm looking at the letter of nomination by Professor Hugh Coder the unnumbered penultimate paragraph, which says, his service as an acting justice of appeal, that is at the SCA as well as on the Constitutional Court of late, will have allowed him to assess his suitability for the role and his colleagues to experience the value which he will bring to the latter court. And my reading and understanding of that sentence is that you have now decided to ditch the SCA and nail your brightest colors to the Constitutional Court mast.
No, I think the answer I gave to your previous proposition is the correct one. Of course, that choice would have confronted me if, in this round of interviews, vacancies had been advertised both in the SCA and the Constitutional Court. That is not the case. I have been encouraged to consider making myself available for the Constitutional Court. It is quite conceivable if my experience thus far of the Constitutional Court being a more grueling workload were to remain the case, that I might have a slightly more restful time if I were to rather not have put my name forward now and perhaps applied next time when an SCA vacancy became available. But I don't think that's what it is about. I think the question is, a candidate comes here, offers or tries to explain what he has to offer, and then it's for the Commission, or in this case ultimately the President, to decide whether one can add value to that court. And it's a duty I'm willing to perform in either court.
Thank you, Justice Rogers. Let us leave it at that. Thank you, Chief Justice. I have no further questions to Justice Rogers.
Thank you, Justice Spetzer. Let me say two things which might be consolation to you, arising out of your question to Justice Rogers. The first one is that when I encouraged him to consider making himself available, he didn't immediately say, yes, I will make myself available. He wanted to reflect. He did indicate that he had been thinking about the SCA. And ultimately, he said, well, he might make himself available for both. That is assuming that there was a vacancy. So I think the SCA was not far from his heart. But the other point I want to make is that he's not the only judge that I encouraged to make himself or herself available. There is another judge that I approached and asked to make themselves available, and I was turned down. And that judge is in the SCA. Thank you very much. Commissioner Lucas.
Thank you very much, CJ. Good afternoon, Judge Roger.
Good afternoon, Ms. Lucas.
Yes, I was looking at your profile a little bit, and I'm going to ask you the same question that I asked one of the candidates earlier, and that is whether you believe that there is a term like judicial activism that exists. Is there any maneuver for a judge to apply the activism in his approach to any case that is coming in front of him?
I suppose it depends precisely what one means. But if by activism one means, as it were, some agenda one has in advance of an issue presenting itself to you before before the issue actually presents itself to you. In other words, you have a view of an end result you'd like to achieve, and you use the cases that come before you to achieve that result. I would not approve of that. The oath of office is that you will, a judge will apply the Constitution and the law without fear or favor. And I think I actually marked up the passage in the judicial oath, because it seems to me that it's the only criterion which a judge needs to bear in mind when any case comes in front of him or her, and that is that I swear that as a judge I will be faithful to the Republic of South Africa, will uphold and protect the Constitution and the human rights entrenched in it, and will administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. And of course, there are a lot of constitutional court judgments which build on that and tell you how you interpret legislation, how you go about a proportionality analysis. It seems to me that if one uses that judicial oath as your guide, one shouldn't need to categorize oneself either as activist or pacifist.
No, it's fine, CJ, because if I ask my other questions, it might take some time.
Okay, no, that's fine. Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge Rogers.
Good afternoon.
My first question is going to be a follow-up to a question asked by Commissioner Dodovo earlier on, and I was very pleased that you spoke about fees, because I wish to submit that to a large extent, access to justice in our country is influenced largely by affordability. And if it was not for legal aid, then many people would find themselves in prison for sometimes crimes that they may not have committed. Now, having said that, you know, we as political office bearers in our parties find ourselves also bearing the brunt of high fees. Because in some cases, you know, I'm the Treasurer General of my party. You know, I've had to pay up to 50,000 rand for Silk not even appearing on the day because the matter was adjourned. And when you question it, they say, well, the day was booked off. And your response was, you can find many other things to do on that day. So I'm appealing to us, Chief Justice. Which body? We've got the bar here, we've got representatives of the attorney's profession. Which body can look at this? For South Africans to benefit from justice, access to justice in our country. Because it's a terrible thing when you have to pay that kind of money and nothing happens on the day. So I wonder how you would respond. What advice can you give to us as a JSC and to South Africans on what should be done about this matter? Thank you.
With your permission, Chair. With your permission, as you respond to that question, you might have regard to Section 35 of the Legal Practice Council, in terms of which rules will have to be made to determine and control the issue of fees, which has not been done as yet.
Yes, I suppose before 2013 I would have had to be more concerned about what my colleagues thought of me. But there is the pro bono route for the truly indigent, but what you're talking about, and I can understand it, when one is dealing with government departments or SOEs or political parties, I suppose there is a sense, well, they've got a sufficiently broad funding base that they can pay. And the answer may very well lie in proper regulation. But it would have to, I don't know if research has begun on potential regulation pursuant to Section 35. As you will know, in other environments, price regulation doesn't always work, or it can sometimes have perverse results. But I think merely wringing one's hands and encouraging people to be more reasonable may not achieve the result. So it may take some form of regulation.
Thank you. Chief Justice, through you, I don't know if the Minister would think that this is a matter for the Competition Commission to look at. And I'll leave it at that on the matter of fees. Having said that, one of the criteria I think that commissioners need to look at, and I say this with respect to all my colleagues that are here, one of the criteria that we have to look at is judicial temperament. And I can recall in 2019 when SCA President Justice Maya had questioned you, Justice Rogers, on your appointment before the SCA, where certain criticisms were leveled against you, of you being arrogant, quote unquote arrogant, of you being high-handed, quote unquote, difficult to work with. And you did say in this interview as well that you set high standards for yourself, which is absolutely 100%. But I think your response at that time in 2019 is that this is something that you would work on. I just want to ask you, have you worked on this kind of aspect, or do you think those allegations were unfounded at that time? Or, were there allegations that you needed to deal with, and have you dealt with it over the period of time from 2019 to now? Thank you.
Yes, I think Justice Meyer was perhaps passing on a little bit of feedback from unnamed persons, which was a bit difficult to deal with. One doesn't know to what extent that on a particular occasion was fueled by if one ended up dissenting or disagreeing with a person on a case that you had heard. My own experience with colleagues in the SCA did not accord with that criticism, but what I found distressing was that there would have been any people who would have perceived it that way, because I don't see myself as arrogant. I think even before then, but since then, I attempt to interact with all colleagues in a way which doesn't convey anything of that kind. And obviously, I'm not going to go into names, but there are many colleagues on the SCA who commissioners could talk to who I think would refute that notion, and not necessarily the strong-minded people or the most forceful personalities, but the sorts of people that perhaps might be more susceptible to arrogance, and that is just the opposite of the feedback I have got from them.
Thank you for that. Chief Justice, the next question.
Chief Justice,
sorry.
Follow up.
Who is
Minister Lamola.
Oh, okay. Right. Okay, Minister. Follow up.
I'm not sure if Councillor Commissioner Singh is done. I wanted to follow up on the access to fees one.
Oh, okay. Maybe shall I just put you on the list here?
Yeah, no, that's also fine.
Okay.
I just
Continue.
have one question more, Chief
Yeah.
Justice. And I don't know if I could ask this question, because this matter that, we all know about publicly could be before the small JSC. And that is the investigation and the conduct of some judges vis-a-vis Judge Mushtaq Parker. I don't know if it's still before the small JSC or not, or could Judge Rogers be asked a question in that regard?
Well, I don't know anything about it. Maybe if you are in doubt, if you can maybe leave it out. It just depends. I don't know anything about the matter you are raising, so I'm not able to guide you.
Okay, what I read somewhere, Chief Justice, was there was an issue of judicial misconduct leveled against certain judges because they didn't want to share a bench with Judge Mushtaq Parker. Now, has that matter?
Okay.
Yes, has that matter been resolved or not resolved, or is it still under investigation? So I wouldn't want to ask Judge Rogers directly if the matter is still being looked at by the...
I'm not up to date about it, so maybe don't ask.
Well,
Yeah.
I can put the...
Or unless Judge Rogers knows.
I'm happy to put Mr. Singh's mind at rest. The only complaint that was lodged against a group of 10 High Court judges was, as I understand it, by Mr. Makwakwa, and that was dismissed I can't remember how long ago, but a long time ago. It was before my last interview. It was certainly more than a year ago. There is a pending complaint by those 10 judges against Judge Parker, and that is the subject of a judicial conduct tribunal into Judge Parker's conduct, but it's not into the conduct of myself or any.
No, thank you very much, Chief Justice. Thank you, Judge.
Thank you. I said I couldn't remember what that matter is about, but when Judge Rogers responded, I thought I might know about it. I hope I was not involved. But there are so many of these matters, sometimes you forget that you were involved in one or other of them. But thank you. I'm going to take Commissioner Nochesi now. After that, I will go to the commissioners who are attending virtually.
So you have forgotten me, CJ? CJ, you
Sorry?
have forgotten me.
No, you are 2 lines down.
Okay, thanks.
Yeah. It's you, then it's Commissioner Baloyi, then it's Commissioner Baloyi, then it's you.
Thank you, CJ. The Chief Justice greeted you on my behalf as well. Don't think I don't want to greet you. I think I have only 2 questions, very short. One, in your interpretation of Section 174(2), which talk to the need for the judiciary to reflect broadly the racial and gender composition of South Africa, and so forth, would you agree with me that in that broad statement, we must build into it geographical spread, not simply to limit it on the question of race, gender? It must include the geographical spread in that court, that is in particular in any court, but in this case in the Constitutional Court.
I see the injunction in Section 174 as directed to the judiciary as a whole. Mm-hmm. It is not in terms an injunction that each court must be a microcosm itself containing that particular balance. I think if one honours broad racial representativity, that may give rise to the geographic spread. I haven't previously thought about the notion that independent of racial and gender issues, there should be a geographic representativity, although I suppose I could say from Cape Town that perhaps it's Cape Town's chance. But,
All right.
but can I say something? Because it did occur to me, obviously, I knew it would be of interest and concern to the Commission, as it always is, that injunction in Section 174(2). And my own view is that that's a policy matter that the Commission decides, but my own view is that the Constitutional Court is a small court. It's very important, but it's only 11 people. It's the apex court. And I almost think that judicial excellence, coupled with a commitment to constitutional values, should be the most important criteria, so that, it struck me looking at, obviously I know who the 5 remaining candidates are, and ultimately it will be if 5 names go forward, it's the President's decision, not the Judicial Service Commission. But it didn't seem to me that whatever configuration of choices were made, assuming 2 people were appointed, whether they were 2 black people or 2 white people, 2 women or 2 men, if the guiding principle was who can make the best contribution at that court in the interests of the country, to say, well, we will not appoint that person because we would prefer, say, a 6-5 split gender-wise or a slightly different split racially. And I accept that that might result in no white people being appointed if that's the conclusion to which one comes. I just think a court of 11 justices is too small, and it is, in this case, too important to allow anything along the lines of a quota to determine who goes onto it.
The last question. If you are in the SCA, matter served before you, say an application for leave to appeal, you dismiss that leave to appeal at the SCA. The following week, you are appointed to act at the CC. Same matter comes to the CC once you are there. Would you preside in that matter?
No, it's happened already, and any judge who was part of an SCA panel immediately withdraws from the consideration of that case.
Thank you.
Before I move on, I just want to make sure that I did not misunderstand you when you said something about the Constitutional Court being too small. Would you care to just repeat the proposition?
Yes,
in the context of the section of the Constitution that Commissioner Nochesi raised with you?
Yes, I wasn't suggesting that there should be more than 11 justices. What I was indicating as a personal view, but recognizing that this is a policy decision rather for others to make, not for me, that in a court where there are only 11 people, the ability to get a broad representativity is compromised because you only have 11 positions to work with. And you are working in a court with a court which is the apex court, where I don't think people would generally disagree that you would want your best judges in that type of court. And all I was suggesting was that if, in the current circumstances, the lodestar of the best judges for the court were used, I do not think it would be retrograde from a constitutional point of view whether that resulted in 2 black candidates, 2 white candidates, 2 women, 2 men. One can do the maths. The court there won't be an equal representativity. There will be some and a significant representativity, but given the current composition of the court, I do not consider that the precise makeup of the 2 people that are now appointed, if 2 are appointed, makes a material difference.
Excuse me. Let me ask this question to make sure I know what you don't mean and what you do mean. Is what you are saying that because this is the apex court of the country, it should not matter if all the judges were men and there were no women, and it should not matter if all the judges were black, there were no white judges, and it should not matter if all the judges were white and there were no black judges, and it should not matter if all the judges were women and there were no men.
No, I don't want to suggest that. It's against a backdrop where currently there are, I'm trying to think, are there 8 permanent members of the court currently, all of them black and I think 3 of them women. And if Justice Meyer, as the President has foreshadowed, were appointed as the Deputy Chief Justice, one would then have 9 black people and 4 women. In that context, I'm saying how you appoint 2 further members to that court isn't going to make, if one used who can make the best contribution rather than striving to achieve, as it were, a quota, then I personally would think that judicial excellence and contribution to the court would be more important. I don't for a minute suggest that in this country we could have a court of 11 white justices. and also in all things being equal, as it were, between candidates, I can readily see that achieving the representativity would be would come to the fore more strongly.
So, are you saying that as long as the judges appointed were excellent, the rest should not matter much? Or are you saying the excellence is important because this is the apex court, but all steps should be taken to make sure that there is a representativity in terms of race and gender? I just want to make sure that
Yes,
we don't finish this interview without me being sure what you were saying.
yes, because I don't sit and have never sat on the side that you sit on, the commissioner's side, having to work out what policy one adopts. I am just expressing a personal opinion, and the practical reality is that we sit with a court currently composed as it is. What I was indicating is that to strive, say, for a 50-50 split between men and women, or a precise racial representativity, that's already not the case based on, personally, if you ask me, if you or ultimately the President considered that the two persons who could make the best contribution to the court were black persons, whether they were women or men, I wouldn't say that that was wrong. And by the same token, if the reverse were true, I think given the current composition of the court, the mandate in section 174(2) is not materially affected by whether the person's, any configuration amongst the current candidates you've got. That's just a personal opinion.
So you confine yourself to the current situation and in regard to the two vacancies?
Yes, if you were starting from scratch, I don't suggest you would, if this was the very first court to be appointed, that you would say, well, it's not of concern that one doesn't have any women or one doesn't have any white people or any black people on the court. I think.
Would a constitutional court that consists of men only be acceptable to you?
No.
And would a constitutional court that consisted of one race be acceptable to you?
Probably not.
Okay, I'm going to go to the commissioners who are attending virtually before I come back. When I come back, the next one will be Commissioner Lloyd. Commissioners who are attending virtually, is there anyone who wishes to put a question to the candidate?
Chief Justice, it's Glynis Breitenbach.
Yes.
Thank you, Chief Justice. I have no questions. Thank you.
Thank you very much, Commissioner Breitenbach. Any other commissioner who wishes to either indicate one way or another attending virtually?
Chief Justice, is Julius here? I don't have any question.
Thank you very much, Commissioner Malema.
Chief Justice, no questions on my side.
Thank you very much, Commissioner Barnett.
Chief Justice, no question from my side have been covered.
Thank you very much, Commissioner Shabango Ndawe. Commissioner Lloyd.
Thank you, CJ. Good afternoon, Justice Rogers.
Good afternoon.
Yes, you've referred to the most recent case that you wrote of the Constitutional Court, that is the Barnett-Sars matter. And that matter related to or raised the issue of the rescindability of your so-called text judgment. Now, and please correct me if I'm right, my recollection is, or in fact, maybe you do say so in the judgment, in paragraph 1, that the first judgment that was delivered in this matter was withdrawn by the Constitutional Court, and then you issued a new judgment. Is that,
yes,
is
that's
that correct?
correct.
Yes. Now, it's often said by judges that judges account to the public through their judgments. So if you want to know what the thinking of a judge was, why certain conclusions were reached, you look to the judgment. You're not going to get an explanation outside of the judgment. Now, in paragraph 1, the question of the judgment being withdrawn, the first judgment, and then being replaced by a subsequent judgment, the best explanation that there is in this judgment is in paragraph 1. It says, you say that, well, firstly, and that's an important factor, I think, you say it was decided without an oral hearing, so there was no public hearing where we could go and see the transcript and see what happened in court. And then you say, shortly after delivery, the judgment was rescinded by the court of its own accord when it emerged that the Revenue Service had filed written submissions of which the court was unaware. And then you say the judgment which follows takes account all of the written submissions. Now, for a reading public, the first curious question is, what does it mean the Constitution, this panel of judges was not aware of these submissions, right? And there's no explanation in the judgment. But, and as I've already said, that there is no transcript or public record to see what accounts for this. And then what then raises concern, if you like, for lack of a better word, is those that were fortunate enough to read the first judgment before it was withdrawn become aware that, in fact, the conclusion, and you can correct me if I'm wrong, the conclusion in this judgment is exactly the same as you had reached in the first judgment. And it raises an interesting conversation of what does it mean? Does it mean, do they even consider these written submissions after they became aware of them? So there are issues. The issues are that there is no explanation why the panel didn't become aware of these submissions. So there's no account for that. 2, how do you assure, and you don't in this judgment, assure the public that whatever was submitted, whatever we found later on, which resulted in the withdrawal of the first judgment, was taken into account? It doesn't change our conclusion that we reached in the first judgment for these reasons. There's simply lacking an explanation of that. That comes across as a lack of accounting to the public for this decision of the judgment, at least to this fault that the first judgment didn't take into account any submissions. So what do you want to say to that?
If you are saying that there should have been a fuller explanation of the administrative oversight which resulted in the members of the court not being aware of the submissions by one of the respondents, I suppose that's a matter of opinion. I would have thought it self-evident, though, that if a judgment is delivered and it immediately becomes apparent because one of the parties remonstrates, they said, but you've now said in this judgment that we didn't file submissions, and we did, and you discover that in fact they did file submissions, the judgment can't stand. That seems to me self-evident, and Rule 42 envisages a rescission under those circumstances. The administrative oversight, I suppose a fuller explanation could have been given. The 9 or 10 members of the court who signed on the judgment thought that explanation sufficient, but if you wish to know, it was an oversight in the general office, the administrative office, in that my clerks had twice checked before the judgment went out with the general office whether the first respondent had filed submissions, and were told that they had not. And those were the circumstances in which the judgment came to be delivered. But the important point was that, for whatever reason, the judgment had been given in ignorance of one party's submissions and couldn't stand for that reason. The second point is that if one compared the first and the second the withdrawn judgment with the judgment which then followed, you will see that all the additional points which were raised in the heads of argument of which the court was originally unaware were dealt with. So there's significant new material in the final judgment which specifically addresses the written submissions that were overlooked and deals with them and meets them head on.
The point, Justice Rogers, that I'm making is the panel of judges that sat here, they know and understand what happened here. The parties that were before you, they understand, or that made submissions, they understand what happened. But for a reading public that sees this paragraph, it seems to me that it is the lack of an explanation puts you, it basically puts in the firing line of criticisms that, but the court doesn't account for what happened here. I think, to speak loosely, it's, well, it seems to be put under the carpet or swept under the carpet what happened. That's the only point I'm making. The second question, my second question relates to your article that you referred to, which is the ethics of a hopeless...
Well, maybe, Commissioner Lloyd, before you move to your next point, I must just come in to confirm what Judge Rogers has indicated about what happened in that matter. It was brought to my attention, and the Secretary General of the Office of the Chief Justice has been asked to investigate, but the indications are that somebody in the Registrar's Office gave wrong information to Justice Rogers' clerks when they said there were no submissions filed by the particular party. And then the judgment was written on the basis that there were no such submissions, but that was actually wrong. But it was only discovered after. So I just thought I must just mention that that is the position. Thank you.
Thank you, Chief Justice. I think it does settle some concerns about accountability. Justice Rogers, the second issue is your article about the ethics of a hopeless case. Now, and as you correctly say, that article is referred to in the case, in the labor court case of Mashishi by Judge Van Niekerk. And fortunately for the applicant in that matter, he wasn't represented. Rather, he was represented, but the matter was not opposed. When in fact, in the tenor of the article of the judgment, it's clear that Judge Van Niekerk considers that, you know, such cases of hopeless cases being brought to court and therefore burdening the court role would, in appropriate cases, warrant cost orders or ordering that counsel or the representatives do not recover any fees. In this case, it wasn't applicable because there was no opposition to the application. Now, the concern that it raises, possible concern, is where do you strike the balance between discouraging what you refer to as hopeless cases and not discouraging parties who believe, or individuals who believe that they have a triable case, misguided as they may be, from asserting their Section 34 right of access to the courts? And we're very much aware that new cases or new arguments come up when, you know, in areas that have never been tested before, and there would be a popular sentiment that there is no case, it's a hopeless case, and yet ultimately it turns out even at the Constitutional Court that, well, there is a case after all that could be made on that, however unlikely it looked like. Now, firstly, it seems that the discouragement, especially to the extent that costs may be used to discourage people approaching court, would have an unequal effect. You may not be represented because your counsel or your attorney doesn't want to be marketed with personal costs. So you're better off going to court alone on your own because you won't meet the same punishment. That seems to be the possible consequence of the concern that you raise with hopeless cases. And yet, if you're not represented, you can approach the court and you're not going to be kicked out. You will be heard, you'll be dismissed in the normal course. Where and how do you strike that balance?
Yes, that is a very difficult question. I suppose one has to start with the proposition, does one accept or does one not accept that eventually a case may be so hopeless that it shouldn't be advanced? Because justice doesn't come at no cost. It may be that the litigants don't pay for the judges and they don't pay for the infrastructure of the court, but justice always comes at a cost to the public purse. And every case that is heard before a judicial officer either causes another case not to be heard or to be delayed in hearing. And it seems to me, therefore, that one must reach a point where one says it is simply wrong that the court should be open to even the hopeless case at a significant cost to the public purse and potential prejudice to the administration of justice for meritorious cases which should be heard. As to where to draw the line, and this isn't a new idea, as the article demonstrates. It does have some significant acceptance in other systems which follow or which have a similar adversarial legal profession to the one that we have. I think the article repeatedly emphasizes that what is not to be discouraged is a weak case. What counsel should not be precluded from doing is arguing a case which, although it is weak and although counsel thinks it will probably lose, can nevertheless be formulated coherently. But just to take an extreme example, assuming there is a constitutional court judgment which shows that the conclusion you're trying to reach is wrong, you just can't get there. And you can't get there without persuading the constitutional court to reverse its decision. And you're now in the High Court and you have no arguments as to why the constitutional court should reverse its decision. To take a case, and it may not even ultimately be argued, it may just be strung out to buy time until a certain point. But such a case is hopeless. If you cannot formulate a coherent argument where each link rests on some evidence that is available, on some legal principle that is arguably applicable, you are abusing the court system. And we just don't have the time and the money to allow the court system to be abused in that way. The dividing line between, I think, what you regard as, say, a case which is challenging conventional thinking. That's also the article. I quote a passage from of what another judge said. You can always put forward heterodox arguments and try to push the envelope. You can argue weak cases. And because you don't want to discourage people from doing their duty to clients by arguing even weak cases to the best of their ability, any cases which are penalized as hopeless must be very clear cases of hopelessness. But I just think that there is and must be such a line to be drawn somewhere. And that was the point of the article. And I set out various circumstances towards the end, which I thought demonstrated why such a point of view had a legal foundation in our own law, including in constitutional values.
Well, Judge Rogers, I do agree that there are the obvious hopeless cases. Really, the debate is always, where do you draw the line?
Yeah, no, I accept that. And if it stimulates a debate amongst people as to how it should be dealt with, that would be good. This was really just the upshot of as you saw, it came up in an advocacy training course, and it caused me to start thinking about it. Why did people think advocates could just go and waste court's time with hopeless cases? Didn't seem to me to be right.
Thank you. Thank you, CJ.
Thank you, Commissioner Baloyi. I now have only 4, and I think the 4 would be the last ones. Commissioner Klaba.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon. I'm sorry. Yes.
In fact, CJ, I've been covered by the previous commissioner,
Yes.
but I will not retire to back to my seat without raising this point.
Okay.
And amongst the extramural activities, you list music. And you say you are a member of the Vocal Assembly in Cape Town, and that you play piano, violin, and guitar. Would you teach the justices of the Constitutional Court to play piano and violin if this house, they just ask you to? Thank you, CJ.
Thank you, Commissioner Clamber. Thank you. Commissioner Schlemmer.
Thank you, CJ. I think adding on to that, I might think it would be easier to make them sing rather than play instruments.
I have made judges sing. We did one at one of our Cape Christmas parties.
That's wonderful. Judge Rogers, I would like to know from you, with your experience now at the Constitutional Court, are there specific things that you would like to see changed in the way in which the court is running? We've heard over the last couple of months of delays in judgments. We have spoken at some of the sittings with some of the candidates concerning the number of judges on the bench, perhaps combining the SCA and the Constitutional Court. What are your views on this? And if you have any different views, please also tell us about them.
Yes, I haven't thought about the idea of combining the SCA and the Constitutional Court. I'm sure you've heard from the candidates who were interviewed for the Chief Justice position. One of the difficulties is that even applications for leave to appeal have to be decided by the full complement of justices in the Constitutional Court. That's one thing that delays matters. Another, that is very time-consuming. Another is potentially, although I know colleagues don't necessarily agree with me on this, is that if it emerges fairly shortly after the hearing, there's normally something, a post-hearing notice circulated within a week. If it's apparent that there's a difference of opinion, rather than letting the nominated scribe complete their first draft and circulate it, to let people from both camps start writing so that second or third judgments don't have to wait until the first judgment has been produced. But particularly the applications for leave to appeal. Within about 6 weeks of being at the Constitutional Court, I got one of these windows on my email server there to say that I needed to empty my delete box in order to carry on receiving emails. I had about 2,500 deleted emails in my delete box. And one can't be away from one's email for more than an hour or two, and they start building up because people have got opinions on things and you've got to process it. So I think cutting down the number of judges and maybe having leave to appeal matters dealt with by 3 justices. I do have ideas about the SCA, but that I think it falls outside the scope of your question.
With your permission.
Sorry, I should have mentioned one point, though, about promptness. One way is obviously to reduce the workload by not requiring all judges to participate in every application for leave to appeal. But I don't think one must overlook that ultimately the speed with which work is produced depends to some extent on judges themselves. And I think it is legitimate when people apply for positions to consider, does this person have a track record of producing work quickly?
Just one last question, if I may. Are all the Constitutional Court judges typing their own judgment, or does it have to go to a typist? I'm just curious about that.
My impression, I actually don't know, but I do mine with voice recognition and dictation, and I think there are a number of judges who do that. There are others that are very quick typists and type their own. I'm not aware of any that, as it were, send off dictation or handwritten notes to a secretary.
Thank you, CJ.
Well, I can tell you that I depend on my secretary for the typing of judgments. Minister?
Yeah, thank you, CJ. It's a follow-up on the access to justice question by Commissioner Singh. I'm not sure if you are aware of the report on Project 142 by the South African Law Reform Commission that was released on the 29th of March. So I'll assume you may not be aware, or you might be, but it speaks on the issues, what the report is aimed to do to address some of the major problems bedeviling the South African civil justice system, such that it takes too long to resolve legal disputes. The system excludes those who cannot afford to litigate in the courts. The average time it takes to resolve a legal dispute ranges between 3 to 6 years, and the legal fees have escalated to a point where the majority of people are excluded from the system of dispute resolution. The high cost of litigation in both civil and criminal matters is one of the main barriers to access to justice. And the questions that must be asked are, what are the factors that give rise to unaffordable legal services? What interventions can be devised to address these challenges in South Africa? So this report deals with these questions. I just want to get your view on some of these challenges and what is your view in terms of dealing with these issues of access to justice?
You're right, I wasn't aware that working paper or report had been issued, and I will track it down and have a look at it. The main emphasis appears to fall on fees and the cost of litigating. I suppose to some extent the cost of litigating is itself a consequence of the complexity of legal procedure. One might say, should one have a more user-friendly form of procedure that perhaps lay people could employ without needing lawyers, or which doesn't have all the complexity and delays built into it. But of course that form of procedure has been designed by and large to achieve fairness to both sides. When you start tinkering with it and trying to cut it down, you might then find that there are cases of unfairness that arise because the procedure isn't as comprehensive as it should be. I still think it is not realistic to imagine in the current legal environment or any highly professional legal environment that fees will come down to a level where the indigent person or even the person of modest means will be able to afford lawyers. The answer must lie in a significant dedication by lawyers to doing pro bono work and representing indigent clients without charging fees or on a contingency basis. I've been out of the bar for 8 or 9 years, so I don't know what the current state of play is of pro bono work. I know both the Legal Practice Council and does try to encourage it, and I think there are professional requirements for pro bono work, but presumably they're falling well short of what the country needs.
Yeah, no, thank you. With your indulgence, CJ, I have the second follow-up on the question of Section 1742, because I think you took him for some time on this question, but I feel like I'm still confused. I'm not sure whether I'm confused because I disagree with him or I just don't understand the response. So I just want to try once with one question. If I'm still confused, maybe other commissioners will help. I'm struggling to understand why it does not matter when we have got these two vacancies who you appoint to add into this issue of the racial and gender composition. While I get your point on that, it's a judicial, it must reflect the entire judiciary and so forth, but I was struggling to understand why it does not matter, because these two, if it is filled, it adds to that composition of the judiciary.
Yes, well, I was looking at the current composition of the court, and I was assuming, but I know one can't take it for granted, that the President makes the appointment of Deputy Chief Justice, which he has foreshadowed. My simple point was this, and I accept that you may not agree with it, but one then has a potential of, say, following any appointments which now get made, of a gender split, say, of 7-4, male, female, or a gender split of 6-5. What I was suggesting is that as between those two possibilities, if the importance of getting as close to a 50-50 split on gender should not, in an apex court, be so critical that one would not appoint a person who could offer the greatest contribution to the work of the court. In other words, I don't think the public looking at this court would say, oh, well, it's got 7 men and only 4 women, and therefore it's not a representative court. But I accept that this is just a personal opinion, that if all else were equal between two equally appropriate candidates, the one would result in a 6-5 split and the other a 7-4 split, I can readily understand that it would be in favor of the 6-5 split. Similarly, it didn't seem to me that from the point of view of the representativity and legitimacy of the court in the public eye, that it would make very much difference whether it consisted of 9 black persons and 2 white people, or 10 black persons and 1 white person. When the court did until very recently have 2 white persons, and I don't think the presence of Justices Cameron and Froneman on the court was thought to impair its legitimacy. So all I was cautioning against, or expressing a personal opinion, that when you've only got 11 positions to work with, one should not be so tied to trying to achieve absolute representativity that you potentially deprive the court of persons who could add more to its work. That's all I'm saying. I don't say that the court should not in a general sense be representative.
No, thank you, CJ.
Thank you, Minister. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Rogers.
Good afternoon.
Justice Rogers, one of the criteria which this body has to consider is whether the candidate is experienced in regards to the values and needs of the community. It's part of the published criteria. In your view, Justice Rogers, are you experienced in the needs of the community?
Only to the extent that intelligently following events, current affairs, reading newspapers, watching television, driving through urban spaces. In that sense, of course, it seems to me that when the needs of the community feature in an actual decision, that is the subject of evidence before the court. And it's not necessarily something which every member of the court must pluck out of their own experience, because one can never be certain that the community needs which feature in a particular case are those of which one has any particular experience or insight. It primarily lies in the evidence in the case, and then I think with respect human compassion. I've enjoyed a relatively privileged background, but if I read about a community where people have to, at night, if they wish to relieve themselves, walk 30, 40, 50 meters to a pit latrine in dangerous circumstances, I can put myself in that position, I think, and have compassion. I can contrast it to my own position and try to understand what is involved for those people. But I haven't, for example, lived in a community which could be regarded as indigent.
But do you always require evidence, Justice Rogers? Are there instances where you could, for example, take judicial notice of what would be a likely outcome? For example, and I see you've kind of appreciated that these questions arise in the context of the Mediclinic decision and the Constitutional Court's judgment in Mediclinic, which was fairly scathing of your majority decision of the Competition Appeal Court. And specifically, I think if you look at paragraph 61 of the Constitutional Court's judgment, Chief Justice Mogoeng says the following: Additionally, the court treated and reduced the predicted and undisputed tariff hike to the level of insignificance. Lest we forget, to the overwhelming majority of South Africans, regard being had to our acute economic inequalities, even a 1% fuel or bread price hike probably constitutes a threat to their presumably shallow pockets and survival. And to the vulnerable group of uninsured patients, it is even more so, with the predicted percentage hike for healthcare services. It was therefore most unfortunate that in the plight of the 100 or 200 uninsured patients that received treatment from the Potchefstroom or Klerksdorp private multidisciplinary hospitals per year was not accorded and handled by the majority with the necessary sensitivity and concern that their vulnerability cries out for and deserves.
Yes, well, a judge in a lower court always has to accept on the chin the criticism that comes. One can't re-argue the case. I think as the minority judges in Mediclinic pointed out, and I think later the Chief Justice did, or the former Chief Justice, actually quoted the passage in my judgment in the Competition Appeal Court where I specifically said even the detriment to a small number of people would be an important consideration if they were a vulnerable group of people. That was specifically recognized. The important point was that the majority in the Competition Appeal Court in that case came to the view that prices would probably go up, not down. Or the prices would probably go down if the merger was approved. So the jury is out on whether prohibiting that merger is ultimately better or worse for the indigent community or the vulnerable community. The reason why the majority in the appeal court didn't find that the ultimate determinant was that on the facts we found that there would be no such detriment and that they would probably be better off, not worse off, if the merger went ahead. And it was in that regard that the majority in the Constitutional Court said, well, we didn't have a sufficient basis to interfere with the tribunal's fact-finding. It's a point on which the Constitutional Court split, but the majority judgment is what it is.
And reading Justice Mogoeng's judgment, I think it went one step further. And it said in certain scenarios, you don't need hard evidence in order to appreciate the likely outcome of a potential price hike, a tariff hike.
Yes, there's no doubt. We accepted, everybody in the Competition Appeal Court accepted that if there was going to be a price hike and it would prejudice even a small group of uninsured patients, it was an important matter. But we found it wasn't going to happen. It was a predictive exercise. The Constitutional Court or the majority took a different view on what would happen with prices. I think everybody agreed that what happened with prices was important if it prejudiced that small number that you spoke of. I certainly recognize it, and I don't need to have lived in an uninsured medical environment to know that it matters to the uninsured patient whether you can or can't afford medical treatment. That's a matter of common sense.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you. We have come to the end of your interview, Justice Rogers. The one thing which I didn't mention at the beginning is that you are also a member of the Competition Appeal Court.
That's correct.
Yes, and how long have you been a member of that court?
I did give the date of appointment. I just don't recall off the top of my head.
About 5 years, about 4 years, 3 years?
About, I'd say 4 or 5 years, yes.
Yeah. Okay, all right. And you acted in the labor court as well at some stage?
Just once. That was before I was a permanent judge.
Yes. Okay,
of the
all
High
right.
Court, yes.
Are there any 2 or 3 points that you want to emphasize to the commissioners before I release you that they should give special attention to when they consider your candidature?
No, I think I've said everything. I just
You've
want
said
to
everything.
apologize for not
Yes.
having asked how you were at the beginning. I didn't know that it would be appropriate.
Okay, all right. Thank you very much, Justice Rogers, and once again, thank you for making yourself available. You are now excused.
Thank you.
Thank you.